We want to get to some more breaking news. Republican Marjorie Taylor Greene of Georgia announcing on social media that she will resign from Congress early next year after a weeks-long falling out with President Trump and much of her party. Now, Greene laid out her reasoning. She said, in part, I have too much self-respect and dignity, love my family way too much. Also, just checking on social media, she did post an announcement just coming in right now. I can put this up, and you can see right there on our screen there. She actually making that announcement. Her message to Georgia's 14th District and America. And she also had her official statement posted online too. She says, I've always represented the common American man and woman as a member of the House of Representatives, which is why I've always been despised in Washington, D.C. and never fit in. She goes on to say Americans are used by the political industrial complex by both political parties, election cycle after election cycle, in order to elect whichever side can convince Americans to hate.
Okay, you need to see this because what just happened in federal court is absolutely devastating for Trump. We're talking about a judge who systematically, methodically, and brutally tore apart every single legal argument Trump's team made, one by one, piece by piece, in front of a packed courtroom. And Trump's lawyers just had to sit there and take it while the judge exposed their arguments as basically garbage. This wasn't just a normal ruling where the judge says, I disagree with your position and rules against you. This was a complete takedown. The judge used phrases like untethered to the facts. The judge said Trump's arguments were not conceived in good faith. The judge basically called out Trump's legal team for making arguments they didn't even believe themselves. And all of this is now part of the permanent court record. Can you imagine being Trump's lawyers in that moment? You walk into court thinking you've got decent arguments, and the judge just dismantles every single one in real time, using unusually harsh language that makes it clear they think you're wasting the court's time with nonsense. That's humiliating. That's the kind of legal beatdown that follows you for the rest of your career. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
The administration has announced that they're going to appeal the ruling. The Trump administration is currently only partially funding the program through November from the nearly $5 billion emergency reserve it has been required to dip into. Let's go to CNN's.
Let me set the scene for you, because the details matter here. This involves multiple cases where Trump has been claiming emergency powers to justify controversial actions, particularly deploying National Guard troops in various situations. Trump's argument has been that he faces urgent public safety threats that require immediate military response. His lawyers have been making these claims in court, arguing that the president has broad authority to use troops domestically when he determines there's an emergency. And judges, including some appointed by Trump himself, are looking at these arguments and basically saying this is complete nonsense. Judge Karin Emergut delivered one of the most brutal takedowns, stating that defendants have made arguments untethered to the facts. That's not just legal language. That's a judge saying you're lying to my court. You're making stuff up. Your arguments have no basis in reality. And then the judge went further, writing that the reasoning was not conceived in good faith. That means the judge believes Trump's team knew their arguments were bogus when they made them. They weren't operating with honest legal disagreement. They were trying to manipulate the court with bad faith arguments. That's one of the harshest things a judge can say about lawyers because it attacks their professional integrity. But it gets worse for Trump. Another federal judge in Oregon blocked Trump's National Guard deployment and specifically noted that Trump's public statements were unfounded with respect to fact. The judge reviewed what Trump was saying publicly to justify the deployment, the threats he was claiming, the emergencies he was describing, and found that none of it was supported by actual evidence. The judge essentially said Trump was making stuff up to justify actions he wanted to take for other reasons. And when a federal judge makes that kind of finding, it's devastating, because it's not just about losing that one case, it's about the judge creating a permanent record that says the president made claims that weren't true. That record can be cited in future cases. It becomes part of Trump's credibility problem going forward. Every time Trump makes similar claims in the future, judges and opposing lawyers can point back to this ruling and say, remember when a federal judge found that Trump's claims about emergency threats were unfounded with respect to fact? Why should we believe him now? The courtroom moments themselves were reportedly intense, judges asking pointed questions that Trump's lawyers couldn't answer satisfactorily, judges cutting off weak arguments mid-sentence and saying, let's move on because this is incredible. Judges making findings on the record that Trump's emergency power claims don't hold up under scrutiny. This is the kind of judicial smackdown that legal observers are calling unprecedented in its harshness toward a sitting president's legal arguments. And what makes this even more significant is that some of these judges were appointed by Trump himself. These aren't Obama judges or liberal activists. These are federal judges who went through Trump's own appointment process. And they're still ruling against him and using harsh language to describe his legal arguments. That tells you how weak Trump's legal position really is, when even judges who might be expected to give him the benefit of the doubt are instead eviscerating his claims in open court. The political implications of this are massive too, because every word a judge says in court gets transcribed. It becomes part of the official record. Media can quote it, political opponents can cite it, and when you have multiple federal judges saying Trump's arguments are untethered to the facts and not conceived in good faith, that's ammunition for everyone who wants to paint Trump as dishonest and power hungry. So what we're watching here is Trump's legal strategy falling apart in real time as judges refuse to play along with weak arguments and instead publicly call out the lack of credibility. This is the judiciary doing its job, checking presidential power, and refusing to rubber stamp claims that aren't supported by evidence. But it's also personally humiliating for Trump because these rulings make him look dishonest and his lawyers look incompetent. And that matters in the court of public opinion, even if Trump's base doesn't care. Because every time a federal judge says your arguments are untethered to reality, you lose a little more credibility with everyone who isn't already in your corner. So let's break down exactly what happened in these courtroom exchanges, why judges are using such harsh language, what specific claims got destroyed, and what this means for Trump's ongoing legal battles. Because this isn't just one bad day in court. This is a pattern of judicial findings that Trump can't ignore and can't spin away. Let's dive in. All right. So let's get into the specifics of what arguments Trump's team made and how judges systematically destroyed each one. Because the details here are important and they show you just how weak Trump's legal position really was. The main issue in these cases involves Trump's claims that he can deploy National Guard troops domestically based on his assessment of emergency situations and public safety threats. Trump has argued that as president and commander-in-chief, he has broad constitutional authority to use military forces to respond to what he determines are urgent threats. His lawyers have been making this argument in multiple cases, essentially saying the president's judgment about when military force is necessary should be given extreme deference by courts. And judges are responding by saying, okay, show us the evidence of these threats. Show us the facts that support your emergency claims. Prove that the situations you're describing actually exist and require military response. And when Trump's lawyers try to provide that evidence, judges are finding it completely inadequate. They're looking at what Trump claims versus what the actual facts show, and they're finding massive gaps between the two. Judge Emerget's ruling is particularly devastating because she went through Trump's claims systematically. The administration said there were urgent public safety threats requiring National Guard deployment. The judge asked for evidence of those threats. The administration provided statements from Trump and some administration officials, but no independent verification, no law enforcement reports showing actual emergencies, no credible intelligence suggesting imminent danger. The judge looked at this lack of evidence and said, your arguments are untethered to the facts. You're claiming emergencies that you can't prove exist. You're asserting threats that aren't supported by actual evidence. And then the judge went further and said these arguments weren't conceived in good faith, meaning the judge believes Trump's team knew they didn't have the evidence, but made the claims anyway. That's a judge accusing the president's lawyers of essentially lying to the court. And that's not something judges say lightly. For a federal judge to find that arguments weren't made in good faith, they have to believe the lawyers knew better, but chose to mislead the court anyway. That's a serious accusation that attacks the professional integrity of everyone involved in making those arguments. The Oregon case has similar dynamics. Trump claimed he needed to deploy National Guard troops because of public safety emergencies. The judge examined Trump's public statements, justifying the deployment, the specific threats he cited, the emergencies he described. And the judge found that these statements were unfounded with respect to fact. That means the judge reviewed the actual evidence and determined that Trump's claims about threats and emergencies weren't supported by reality. The judge essentially said Trump was making stuff up or grossly exaggerating minor issues to justify military deployments he wanted for other reasons. And this finding is particularly damaging because it directly attacks Trump's credibility. When a federal judge rules that your public statements are unfounded with respect to fact, that's the judicial equivalent of calling you a liar. It's a permanent record that says this person made claims that weren't true. And that record follows Trump into every future case where he tries to make similar claims. Let's talk about the courtroom dynamics because reports from people who were there describe just how brutal these exchanges were. Trump's lawyers would present an argument and judges would immediately start asking pointed questions that expose weaknesses. Show me the evidence for that claim. Where's the law that supports that interpretation? How do you reconcile your position with this Supreme Court precedent? And Trump's lawyers would struggle to answer. They'd try to pivot to different arguments. They'd claim they'd provide evidence later. They'd argue that the president's judgment should be trusted without extensive proof. And judges would shut that down. They'd say, no, you need to show me evidence now. No, the president doesn't get unlimited deference when constitutional rights are at stake. No, I'm not accepting vague assertions when you're asking me to approve military deployments in American cities. The judges were holding Trump's team to normal standards of legal argument and evidentiary support, and Trump's team couldn't meet those standards. One particularly brutal moment, according to legal observers, came when a judge pointed out that Trump's lawyers appeared to know their own arguments wouldn't hold up. The judge essentially said, "You're making these claims, but I don't think even you believe them." That's extraordinary. That's a judge telling lawyers to their faces that the court sees through their arguments and recognizes they're making bad faith claims. Most judges are more diplomatic, even when ruling against weak arguments. But to directly state that arguments weren't conceived in good faith and that lawyers appear not to believe their own arguments, that's the judicial equivalent of a verbal slap. It's the judge saying, I'm not just rejecting your arguments, I'm calling out the fact that you're wasting this court's time with nonsense you know is nonsense. The legal implications of these rulings extend far beyond just these specific cases. Because judges are making findings about Trump's credibility and the credibility of claims his administration makes about emergencies and national security threats, those findings become precedent that other judges can cite. They become part of Trump's track record that prosecutors and civil plaintiffs can use in future cases. They make it harder for Trump to claim emergency powers in the future because judges will look at these rulings and say, last time you claimed an emergency, federal judges found your claims were untethered to facts. Why should we believe you now? This creates a credibility deficit that compounds over time. The National Guard deployment issue is particularly significant because it touches on fundamental questions of presidential power and civil-military relations. The Constitution and various laws place strict limits on when and how presidents can use military forces domestically. There are good historical reasons for these limits. The founders didn't want presidents using the military as a personal army to intimidate civilians or enforce their will on American cities. So there are procedures and legal requirements that must be met before deploying troops domestically. And Trump has been trying to bypass or stretch those requirements by claiming broad emergency powers. He's essentially arguing that when he determines there's a threat, he can deploy troops without meeting normal legal standards. And judges are saying, no, that's not how this works. You don't get to unilaterally decide there's an emergency and use that as justification to deploy military forces. You need actual evidence of threats. You need to follow proper legal procedures. The political fallout from these court beatdowns is also significant because every harsh judicial ruling gives Trump's opponents ammunition to use against him politically. Democrats will cite these rulings to argue Trump is dishonest and power-hungry. Critics will point to judicial findings that Trump's claims are untethered to facts as proof he can't be trusted. Media coverage will focus on the unusually harsh language judges use and what that says about how weak Trump's legal positions are. His supporters will probably dismiss these rulings as more evidence of biased judges and a rigged system. But persuadable voters, people who aren't fully committed to either loving or hating Trump, might look at these judicial findings and think maybe there's something to the criticism that Trump abuses power and doesn't tell the truth. There's also the practical effect on Trump's ability to govern going forward. If judges are going to scrutinize his emergency claims this carefully and reject them as unfounded, that limits his options for responding to situations he views as crises. He can't just declare an emergency and deploy troops if courts are going to demand extensive proof that genuine threats exist. That constrains presidential action in ways that Trump finds frustrating, but that's exactly what checks and balances are supposed to do. The judiciary is checking executive power and making sure presidents follow the law even when they don't want to. The permanent record aspect of these rulings is also crucial. Everything said in court gets transcribed. Judicial findings become part of the official record that anyone can access and cite. So when Judge Emergent writes that Trump's arguments are untethered to facts and not conceived in good faith, that becomes a permanent statement that will follow Trump forever. Future historians will cite these rulings when evaluating Trump's presidency. Legal scholars will reference these findings when discussing presidential power and its limits. Political opponents will quote these harsh judicial assessments in campaigns and hearings. You can't erase these rulings or spin them away. They're part of the permanent legal record. And that matters because it means Trump's claims about being treated unfairly by courts have to contend with the actual written record of what judges found. People can read the rulings themselves and see that judges weren't just disagreeing with Trump on policy, they were finding that his factual claims were false and his legal arguments were made in bad faith. That's a much more damaging narrative than just Trump lost some court cases. It's a finding that goes to credibility and honesty, which are fundamental to any president's ability to lead effectively and maintain public trust. Okay, Let's break this down into clear points so you understand exactly what happened and why it matters so much. Point number 1. Trump's legal arguments about emergency powers and National Guard deployments got systematically destroyed by federal judges who found them untethered to facts and not made in good faith. That's not normal judicial language. That's not judges politely disagreeing with legal interpretations. That's judges saying your arguments are garbage and you knew they were garbage when you made them. When a federal judge finds that arguments weren't conceived in good faith, they're saying the lawyers were trying to mislead the court. That's a serious accusation that damages the credibility of everyone involved. And when multiple judges across different cases are reaching similar conclusions about Trump's claims, it creates a pattern that's impossible to dismiss as isolated judicial bias. Point number 2. Judges specifically found that Trump's public statements about threats and emergencies were unfounded with respect to fact. Think about what that means. Trump went out and made public claims about threats requiring military response. Federal judges examined those claims against actual evidence and determined they weren't true. They were unfounded, not supported by facts. That's a judge calling the president a liar in the most formal, official way possible. And it's not just my opinion or political spin. It's a judicial finding that's part of the permanent court record. Anyone can read these rulings and see that federal judges determined Trump was making false claims about emergencies to justify controversial deployments of military forces. That's devastating for Trump's credibility in future cases. Point number 3. Some of these judges were appointed by Trump himself, which makes their harsh rulings even more significant. Trump can't dismiss these findings as coming from Obama judges or liberal activists trying to undermine him. These are judges who went through his own appointment process, who might have been expected to give him the benefit of the doubt, and they're still ruling against him with unusually harsh language. That tells you how weak Trump's legal arguments really were. Even judges who might be sympathetic to Trump or inclined to defer to executive power looked at these arguments and said, no, this is too far. These claims aren't supported by evidence, and we're not going to pretend otherwise. When you lose judges you appointed, when they use language like untethered to facts and not conceived in good faith, that's a sign your legal position is fundamentally unsound. Point number 4. These judicial takedowns happen in open court, in front of witnesses and reporters, making them public spectacles that damage Trump politically as well as legally. This wasn't judges quietly issuing written opinions that few people would read. This was judges verbally eviscerating Trump's arguments in packed courtrooms with legal observers and media present to witness the beatdowns. Reports described Trump's lawyers looking stunned and scrambling to respond as judges methodically destroyed each argument. That kind of public legal humiliation has political consequences. It makes Trump look weak and dishonest. It makes his lawyers look incompetent. It provides footage and quotes that opponents can use in campaigns and hearings. Even if Trump's base doesn't care, those narratives matter for persuadable voters and for other political actors deciding whether to support or oppose Trump on various issues. Point number 5. These rulings establish important precedents that limit presidential power and make it harder for Trump or future presidents to claim broad emergency authority without proof. The judicial findings here that presidents can't just assert emergencies without evidence, that claims about threats must be supported by facts, that courts will scrutinize emergency power claims carefully rather than rubber stamping them, these become part of constitutional law going forward. Future courts will cite these cases when evaluating presidential emergency claims. The checks and balances system is working here. The judiciary is imposing limits on executive overreach and making clear that claims of emergency authority require actual proof of emergencies. Now let's talk about what happens next, because these judicial beatdowns have consequences beyond just the specific cases where they occurred. Trump's legal team has to figure out how to respond to rulings that don't just reject their arguments, but actively question their good faith and credibility. That's a difficult position to be in, because you can't just appeal and hope the next court sees things differently. You have to deal with the fact that trial judges have made findings about your lack of credibility that will follow you into appeals in future cases. Trump's usual strategy of attacking judges as biased is harder to execute when those judges are his own appointees and when their rulings are based on careful examination of facts rather than just policy disagreements. For Trump's broader legal strategy, these rulings are a disaster because they strip away the veneer of legitimacy from his emergency power claims. He's relied heavily on asserting that he faces urgent threats requiring immediate action and broad authority. But when judges examine those threat claims and find them unfounded, it becomes much harder to use emergency authority as justification for controversial actions going forward. Trump either has to actually prove genuine emergencies exist, which requires evidence he apparently doesn't have, or he has to find different legal justifications for the actions he wants to take. The political ramifications extend beyond just Trump's immediate legal problems. These harsh judicial rulings give Congress more ammunition if they want to pursue oversight. They give state officials more confidence to resist Trump's demands if they believe federal courts will back them up. They give other parts of the federal government, including military leaders who might be uncomfortable with questionable deployments, legal cover to push back on orders they view as improper. The precedent-setting aspect of these rulings is also significant for the long term, because the legal principles being established here, that emergency power claims require evidence, that courts will scrutinize presidential assertions carefully, that judges won't accept bad faith arguments even from the executive branch. These principles will outlast Trump's presidency. Future presidents will be constrained by these precedents. Future courts will cite these cases when evaluating executive power claims. The constitutional balance between presidential authority and judicial review is being recalibrated through these cases in ways that will matter for decades. Here's the bottom line. Federal judges, including Trump appointees, just delivered brutal courtroom takedowns of Trump's legal arguments, finding them untethered to facts and not made in good faith. They specifically ruled that Trump's public statements about threats and emergencies were unfounded, creating a permanent record that the president made false claims to justify controversial military deployments. These weren't quiet legal disagreements. These were public judicial beatdowns where judges used unusually harsh language to eviscerate Trump's arguments in packed courtrooms. The political and legal implications are enormous. Trump loses credibility for future emergency power claims. His legal team has to operate under the shadow of judicial findings, questioning their good faith. Precedents are being set that constrain presidential power and require actual evidence for emergency assertions. So what we're witnessing is the judiciary finally imposing real checks on presidential overreach after years of Trump testing boundaries and finding ways around legal constraints. These judges are saying enough. We're not going to pretend your arguments make sense when they don't. We're not going to accept claims without evidence just because you're the president, and we're going to use harsh language to make clear that bad faith arguments won't be tolerated in our courts. Whether this judicial pushback continues and whether it actually constrains Trump's behavior remains to be seen. But what's already clear is that Trump can no longer count on courts, even courts with judges he appointed, to give him the benefit of the doubt or accept weak arguments. He's going to face real scrutiny, and when his arguments can't withstand that scrutiny, he's going to lose in ways that are public, permanent, and politically damaging. This is what accountability looks like. When the system works, it's messy, it's slow, and it happens in fits and starts. But when federal judges are willing to call out the president for making unfounded claims and bad faith arguments, when they're willing to do so publicly and in harsh language that leaves no doubt about their findings, that's the check part of checks and balances actually functioning. And that matters for anyone who cares about rule of law and constitutional limits on power. Because if presidents could just claim emergencies without proof and use those claims to deploy military forces or take other extraordinary actions, there would be no meaningful limit on executive power. These judicial rulings are saying there are limits, we will enforce them, and presidents who try to manipulate the system with false claims will face consequences. That's a powerful statement about the resilience of constitutional governance, even under stress. So pay attention to these court cases. Read the actual judicial opinions if you can find them. See for yourself what judges are saying about Trump's arguments and credibility, because this is history happening right now. The legal system confronting presidential overreach and making hard choices about how to enforce constitutional limits. And the outcome of this confrontation will shape American government for years to come.